Joumana Kayrouz. You've seen her images on giant billboards across the metro. Joumana Kayrouz. You've seen her images on buses across the city. Now get to know Joumana Kayrouz.
The war broke out in my home country, Lebanon. I was 11 years old, and I saw a lot of bloodshed and inequality and poverty. You can't grow up in an environment like that and not be affected by it and not want to make a difference. I graduated from Yale University with a master's in ethics. I speak 4 languages. It has always been innate in me fighting for the underdog and trying to do whatever it is I can to make a difference in the world.
Let Joumana Kayrouz protect your rights. Call the law offices of Joumana Kayrouz at 1-866-YOUR-RIGHTS, extension 100, or visit yourrights.com.
قد يحاول بعض المصابين في حوادث السيارات إدارة قضاياهم توفيرا لأتعاب المحامين، والآن مكتب المحامية جومانا كيروز بإمكانه المساعدة من خلال إشرافه على سير القضية في جزئها الأول المتعلق بتعويضات الراتب والخدمات المنزلية، وتقوم بإرشادك في كيفية إدارة ملفك مجانا، بينما سيتولى المكتب مهمة الدفاع عن قضيتك في جزئها الثاني المتعلق برفع دعوى عن عطل وضرر. للمزيد من المعلومات اتصلوا بمكتب المحامية جومانا كيروز والاستشارات مجانية 248-557-3645. برنامج يور رايتس مع المحامية جومانا كيروز المختصة في قضايا حوادث السيارات، مع نخبة من المحامين في اختصاصات عدة منها الطلاق والهجرة والإفلاس، يأتيكم الآن على الهواء مباشرة. طابت أوقاتكم بالخير، أهلا بكم مستمعينا في حلقة جديدة من برنامج يور رايتس مع المحامية جومانا كيروز، ومعنا اليوم المحامي مايكل بنكستين. للمشاركة على الهواء في هذا البرنامج بإمكانكم الاتصال على الأرقام 313-769-6666 519-256-1023، وأيضا عن طريق الواتساب برسائل نصية أو صوتية 313-327-7074. مكاتب المحامية جومانا كيروز تتعامل مع قضايا الإصابات الشخصية من ضمنها حوادث السيارات، إصابات العمل، الأخطاء الطبية، الهجرة والتجنس والإفلاس، وقضايا الضمان الاجتماعي. للاستشارات بإمكانكم التواصل مع المحامين والمحامي جومانا كيروز أيضا 248-557-3645. تحياتنا لكم جميعا. جومانا، مساء الخير.
مساء النور رامي، يعطيك ألف عافية بهالنهار الممطر. How are you؟
أهلا وسهلا، سعداء بلقائك، وأكيد نرحب بك في برنامج يور رايتس.
شكرا جزيلا رامي، مساء الخير لكل المستمعين ولضيفنا لليوم مثل كل نهار جمعة المحامي مايكل بنكستين. الأرقام هي 313-327-7074 ليلي بيحب يبعت واتساب على الراديو، واللي بيحب يتصل 313-769-6666. Good afternoon, Attorney Michael Benkstein. How are you?
Good afternoon, Joumana. I'm great. How are you?
I am good. Thank you very much. We are going to talk about a couple of things today. Let me pose these questions so that the listeners know that we will be talking about people who are married. And number one, we will define what does it mean to be married. If you are only religiously married, does that mean you are married? But once we define that, people who are married sometimes need to file bankruptcy. The question becomes, should one of the spouses file or should both of the spouses file? When is it a good idea for the one spouse to file? When is it a good idea for both spouses to file? We're also going to talk about when only one of the two spouses files, whether the income of the non-filing spouse is high enough that the filing spouse or the want-to-be filing spouse will not be even allowed and permitted to file because of her other spouse's income. So we are going to talk about every possible scenario for married couples. We're going to define what marriage under the law, number one, and then to file jointly or to file separately is the question. To file separately or not separately, to file jointly or not jointly, and when does the income and the financial health of your spouse come in the way and prevent you from filing bankruptcy. And then if our time remains, we're going to go back to something that we did talk about before, which is when you fear to be sued, say by a credit card company, or you were served for a money judgment, or there is a money judgment against you, what should you do? And how can you protect yourself from dangers such as, having wages being garnished by your employer, having your bank accounts being garnished, having your tax refunds being intercepted, having some other payments that you probably get, um, like, rent payments and any other payments you have under a contract um, being taken away from you. And back in February, we talked about the forms. There is something called a garnishee disclosure form and something called an income tax refund credit garnishment form. So we will talk about those in greater detail as well. So, Michael, we're going to start by talking about the married couples. First of all, can you tell us under the law, who is considered married?
People who are considered married are people who are civilly married.
Okay. And to be civilly married, what do you need to do?
Under Michigan law, it's necessary to obtain a marriage license from the county clerk in the county in which either one of the two people resides.
Okay. So it is okay to be religiously married, whether it is with an imam or whether it is with a priest. However, you have to turn it into a marriage recognized by the state of Michigan, and I assume every other state, but let's speak for the state of Michigan. You have to make an extra step if you just got religiously married by going to City Hall and applying for what is called a marriage license. Once you do the marriage license, when you apply for a marriage license and you fill out the marriage license, and that can be filled out by your sheikh or by your priest, then you can turn that into a civil marriage. Now we are talking about two people married in the eyes of the law here in Michigan, correct?
That is correct.
Okay, so it's okay to have a religious marriage. You just need to make an extra step, which is apply for a marriage license, fill that out, and have that on file in the county where you got married. That can be filled out by your religious leaders, but you have to take that extra step. So now, when we talk about uh, the filing for bankruptcy, the first thing you ask someone when they come to you is, "Are you married?" And if they say no, by the way, just in passing, you also ask a very important question. Have you been divorced in the last 10 years? And tell me, why does the bankruptcy court and the bankruptcy trustee who acts on behalf of the bankruptcy court, why does the trustee care about whether somebody has been divorced in the past 10 years?
Thank you, Joumana. The trustee appointed by the bankruptcy court tends to ask if you've been married within the last 10 years because there may be property division provisions in the judgment of divorce that the bankruptcy court has to take into account.
Okay, so before we talk about, married people, they want to know because maybe you are getting money, and that money, if now you want to file for divorce, is something that the bankruptcy trustee is interested in, because that will allow the trustee to see if you qualify for Chapter 7, or if it is Chapter 13, maybe some of that money you've been getting in the divorce in the past 10 years needs to pass on to your creditors. Now, let's put that aside for a minute. Moving on, let's talk about when somebody comes and one of the questions you ask them is, "Are you married?" And once you confirm that they are civilly married, sometimes the woman will come to you or the husband will come to you in a marriage, and they're telling you, "I want to file for bankruptcy." What are some of the questions that you ask, and why do you care to ask? If the wife or the husband, doesn't matter, comes to you and says, I in the marriage want to file, why do you go above and beyond and you care to know what the other spouse, how much that spouse makes an income, what that spouse's expenses are? Why do you care? And why does the court care?
Here's why I care. Because when somebody comes in for a consultation with me, they have questions, and those questions are very important. And I answer those questions. But I also have a job to answer some of the important questions they didn't ask. So if somebody comes in and they say, you know what, I want to file, my spouse doesn't want to file. I mean, ultimately, that's their decision. But I want to make sure when they're making that decision that they have all the relevant pieces of information necessary to make the best decision for them. So what I tell that person is, well, first of all, okay, how much is your debt? Does your spouse have any debt? And I get what you're saying. They don't want to file. You don't want them to file. But just out of curiosity, just satisfy my curiosity for a moment. How much debt do they have? And if they say, oh, it's $1,000 or $2,000, okay, well, that makes sense for you to just file jointly yourself and then have your non-filing spouse, keep their credit score good. That makes sense. Now, if you say they owe $20,000, and I would say something like, well, you have the right to file as an individual, but I just want to let you know, if you file for bankruptcy, that eliminates your legal obligation to pay your debts. It doesn't do anything to your spouse's debt. So it might not fix the problem for the household financially if you still have $20,000 hanging out there running from 18 to 31% interest. So I like to, it's sort of like they're the president, I'm the general. I like to lay out a menu of options and let them know what happens if you do this, what happens if you do that. And then if ultimately they still say, I get what you're saying, but I want to file as an individual, that's fine. But they can't say they didn't know, kind of what the moving parts were. That's the way I do it.
Okay, so once you determine that somebody is civilly married, you inquire a little bit about the other spouse who is not here in the office today. You want to know how much money they make. You want to know what their monthly expenses are. You want to know if they have a lot of debt. And the reason you ask these questions is because, and you also want to know whether the debt that is bringing the person to your office today, that she or he is seeking to wipe out through bankruptcy, is not going to be, after you file for bankruptcy for your client, is not going to be 100% on the non-filing spouse, because then that defeats the purpose. Let's go into specific examples. For example, if somebody comes to you, and we're going to translate all this into Arabic. If somebody comes to you, say the wife, and the number one reason, or one of the main reasons for why she wants to file for bankruptcy, but she does not want her husband to file because she wants to save, quote unquote, his credit score. You determine that $40,000 of, she has $40,000 in credit card, and you see that the credit card is in her name and in her husband's name. Well, great. She can file for bankruptcy, but this is not going to solve her problem, because once she files for bankruptcy, her responsibility as to the $40,000 is done. But guess what? Her husband is on the credit card. So for that reason, he is responsible for 100% of the 40,000. So it does not help her, not unless maybe she's separated from him and she does not care. But if they are still in a good relationship, living together as husband and wife, it's not going to help her to file for bankruptcy, because 100% of that joint debt is now on her husband. So that does not really solve the issue. Another reason you want to know about the husband, if the husband makes $100,000 a year, and I'm just using an example, it could be way less, it could be way more, she may not even be a candidate for bankruptcy, because the court will look at, if you are living in the same household, it's going to look at not just you wanting to file for bankruptcy, but if your husband makes good money and the expenses aren't that great, then you want to file for bankruptcy, a petition for bankruptcy, but the bankruptcy trustee may file a motion to dismiss it because there is too much money coming into that household. Yes, you may not have the money as half of that marriage, but your husband makes enough money that they take a look. Yes, you're the one filing for bankruptcy, but because of your legal status as being married, the law says, the Congress said, the courts say, we're going to look at that entire household. not just as you. It's a little bit for when you apply for SSI. They look at, when you apply for SSI, they don't just look at you. They look at who's living with you, how much money is coming to the household. That is a factor. That is a determination in deciding whether you qualify for filing for bankruptcy. So, and the questions we're getting as soon as we finish that discussion on married couples, who is married and when to file separately and when to file jointly. We will answer those questions. But going back, so these questions are not because we are nosy. And the third scenario is, so the first scenario is if you have joint debt, you filing is not going to help. Unless you're separated and you don't care. If your husband or your wife makes too much money, you will not qualify for filing. And the third thing is, again, if you have a lot of debt and your spouse has a lot of debt, you're better off filing jointly and calling it a day, because there's a problem here, and you filing is not going to take care of the other spouse's problem, so you might as well file. Now, Michael, when say a wife comes to you and she wants to file, and then you discover during the discussion that the husband also has a lot of debt, do you file them together, joint?
Yes, it doesn't matter whether you own, it doesn't matter whether the debt that's owed, the underlying debt owed is joint between you both. It could be that she has a lot of debt and totally independent of her debt, the spouse has a lot of debt. When you're married, you have the ability to file a joint case and eliminate each of your debts, even if it's not held jointly. So the joint separate debt, it really doesn't matter. I mean, the main thing is, do you each have a lot of debt? If you both, all things being equal, if they both have significant debt, it makes sense for them to file jointly and eliminate the debt.
Okay. Tell them the story about a lady who was going to get married to somebody quite prosperous or wealthy, but she wanted to file for bankruptcy. You strategically assisted her in filing for Chapter 7 before getting married, because if she waited to get married, like we said, now as half of the married couple, the court was going to look into all the income coming into that household, and she will not have qualified. So what you did is, you had her file and get discharged from bankruptcy before she married her husband, correct?
That's correct. She got her discharge and the court closed the case just a little over a month before the marriage. So, that's just where, good lawyering is involved.
Okay, very, very, very good. So I think we've addressed all of that. Before we translate, let's take a couple of questions. Mr. Khaled says, can a lender repossess my car during Chapter 7 bankruptcy? So we're talking about, and this is a question we get asked regularly, if you are already in the midst of Chapter 7, can your car be repossessed? Answer, please, Michael, if the Mr. Khaleds of the world have not been current on paying, and answer, please, if the Mr. Khaled of the world have been current on paying the car.
Well, I'll answer the easy one first. It's if he's not behind on the car, the car lender wouldn't have any reason to repossess it. But when you file a bankruptcy for any kind of debt, there's an automatic stay that goes into effect. That means that your creditors cannot engage in any activities for purposes of collecting a debt. They can't call you. They can't write you. They can't sue you. They can't garnish you. Everything has to stop. Now, if you're behind on the car, the creditor, who's notified of the bankruptcy, now if they want to get the automatic stay lifted with respect to their debt, they would have to file a motion with the court. There's a 14-day notice period. So right away, when you file the bankruptcy, before bankruptcy, if you're behind on your car note, you could just wake up one morning and the car is gone. They jacked it up on the truck at 3 a.m. or something. But once you're in bankruptcy, that can't happen without notice and an opportunity to respond. Now, if it turns out you're a month behind, but now that you're not having to pay your credit card debt, now you do have the money to catch up on the car, you could respond and say, okay, well, I was behind at the time the case was filed, but here's my idea for how I'm going to, pay this up. And, you can get it current. And, then there's no reason to lift the stay to allow them to repossess the car.
Okay, so the short answer is, before you file bankruptcy, anybody can get to you. Once you file bankruptcy, everything freezes. Nobody can call you, nobody can sue you, nobody can hound you, and nobody can get your car. In order for them to do that, and sometimes they do that because you can't have the cake and eat it too. You can't be driving that car and not paying on it. So they have to do one extra thing. If you have already filed Chapter 7, they have to go to court. They have to ask to lift, meaning take out that freeze, and explain to the judge why they want the car back. So it doesn't happen automatically. If you've already filed Chapter 7, you are not going to wake up and see your car gone. Because if you remember, we've said that many times on the radio, when you file a petition for bankruptcy, you list all of the people to whom you owe money, whether you're current on it and paying on time or not. The court will turn around and notify in writing all of these creditors, including your ex-spouse who gets monthly child support from you and child and alimony from you and so forth. Anybody you owe money to, whether you're current or not, will get a notice in the mail as soon as you file a petition by the court. The court will do that. The court will send those notices that you have filed bankruptcy. So that's how they will know. Now, again, if you filed for bankruptcy, they'll have to take that extra step of, lifting the stay, going to the bankruptcy court and explaining their case and saying to the judge, Your Honor, he's not paying for the car and he wants to drive the car. That's not fair. We need to get the car back. Correct, Michael?
That's correct.
Okay. Let's take another question. Mr. Ahmed says, can I file for bankruptcy if I am unemployed? Well, correct me if I'm wrong, Michael, but your status of employed or unemployed has absolutely nothing to do. If anything, it makes your case a lot stronger because you have no money left at the end of the month, unless you're getting unemployment. And go ahead, answer it.
Sure. There was a really weird situation last year because of the pandemic and because the federal government massively increased the unemployment payments, that for a short period of time last year, there were cases that otherwise would have been a Chapter 7 that we had to kind of wait until the federal subsidies expired. So their unemployment income went back down to a place where they could file a Chapter 7. But that was a really extraordinary once in a lifetime situation. Really, any source of your income, whether you're employed, unemployed, second job, third job, over the table, under the table, Lyft, Uber, DoorDash, what have you, you have to list all of your income. So there's nothing about being on unemployment that keeps you from filing for bankruptcy if you otherwise qualify.
Okay, let's answer the third question being sent to our radio WhatsApp number, and that number is 313-327-7074. Again, if you want to send your questions regarding bankruptcy off the air, you can send them to the radio WhatsApp number 313-327-7074. Let's answer this question and then take a quick break, quickly translate all this into Arabic and continue with our show and questions. Somebody asked, after you file for bankruptcy, how soon can you get a mortgage? I think the larger question is, how soon can you recover from bankruptcy, which takes your credit score to the lowest it's ever been? And how soon can you recover to the point that a bank or a lending company will give you a mortgage?
Well, in terms of a mortgage, you'd probably have to be at least 3 years out from the mortgage. There's nothing magic about that. There may be somebody who gives it to you sooner than that. But what happens basically is when you file for bankruptcy, that fact that you filed for bankruptcy does appear on your credit report for 7 to 10 years, depending on the credit reporting agency. What I have found, and your credit does take a little bit of a hit when you first file, but so long as you don't get behind on anything else moving forward after the bankruptcy was filed, it does improve over time. It probably have to get about 18 months out or so for it to improve enough for you to know there's a difference. On a bigger ticket item like a mortgage, could be 3 years or so, but you can get credit cards after. People get cars afterwards. It may not be right away. It may not be the best interest rate you've ever seen right out of the starting gate. But yeah, a mortgage would probably be at least a good 3 years after.
Okay, thank you very much. Let's take a very quick break and we will return. We are, like every Friday, talking with attorney Michael Benkstein from our office about bankruptcy and bankruptcy-related matters. The number to call, 313-769-6666, 313-327-7074. 7074. And Rami will be uploading this onto our Joumana Kayrouz YouTube channel. People can listen to it after and share. Thank you.
قد يحاول بعض المصابين في حوادث السيارات إدارة قضاياهم توفيرا لأتعاب المحامين، والآن مكتب المحامية جومانا كيروز بإمكانه المساعدة من خلال إشرافه على سير القضية في جزئها الأول المتعلق بتعويضات الراتب والخدمات المنزلية، وتقوم بإرشادك في كيفية إدارة ملفك مجانا، بينما سيتولى المكتب مهمة الدفاع عن قضيتك في جزئها الثاني المتعلق برفع دعوى عن عطل وضرر. للمزيد من المعلومات اتصلوا بمكتب المحامية جومانا كيروز والاستشارات مجانية 248-557-3645. هل أنت مضطر إلى إشهار إفلاسك؟ لا تأخذ هذه التجربة لوحدك، بل استشر أولا ومجانا مكاتب المحامية جومانا كيروز، وتكلم مع المحامي المختص بقضايا الإفلاس مايكل بنكستين، الذي سيساعدك على التخلص من ديونك وفقا للبند السابع لقانون الإفلاس بسعر $575 فقط. ومن الممكن أيضا أن تحصل على إعفاء من أتعاب المحكمة اعتمادا على عدد أفراد الأسرة ومدخولك الشهري. اتصل الآن بمكاتب المحامية جومانا كيروز 248-557-3645 والاستشارة مجانية. Your Rights مع المحامية جومانا كيروز. عودة إلى برنامج Your Rights مع المحامية جومانا كيروز، والحلقة اليوم مخصصة لقضايا الإفلاس مع المحامي مايكل بنكستين. بإمكانكم المشاركة في البرنامج على الهواء، والأرقام في الاستوديو 313-769-6666 519-256-1023، وأيضا عن طريق الواتساب الرقم هو 313-327-7074. جمانة نرجع لك.
جاوب على الأسئلة اللي حكينا بالإنجليزي، ونرجع منترجم عن موضوع الأشخاص المزوجين. شو يعني متزوجين؟ وهل لازم واحد منهم يقدم أيمت لازم اثنيناتهم يقدموا إلى آخره. أول سؤال من الأستاذ خالد بيقول إنه هل بيقدر الشركة اللي هي أو اللندر اللي أنا مقسط منها السيارة يعملوا لي ريبوسيشن أو بيسموها ريبو إذا أنا مقدم Chapter 7 bankruptcy. رامي، وقت الإنسان بيقدم Chapter 7 bankruptcy هي إنذار the whole world كل العالم إنه ما بقى حدا بيقدر يقرب عليك، لأنه صار عندك حصانة، صار في stay بيسموها freeze. كل شيء العالم بدها منك ما بيعود فيها تقرب عليك، ما بيعود فيها تتصل فيك، ما بيعود فيها تتواصل معك، ما بيعود فيها تبعت لك رسائل، ما بيعود فيها تقيم دعوة ضدك. وإذا غلطت تقيم الدعوة will get dismissed. ليه؟ لأنه أنت محصن، قدمت bankruptcy. تكون محصن بدك تكون مقدم bankruptcy، مش نهار قبل. شو بيصير؟ كيف بيعرفوا أصحاب الديون إنه أنت قدمت bankruptcy؟ وقت بتقدم bankruptcy petition for bankruptcy في schedules مطلوب منك تعبيهم كجزء من البيتيشن، بتقول فيهم كل الديون اللي أنت عندك، الديون اللي أنت عم تدفعها on time والديون اللي أنت مأخر فيها، الديون اللي أنت ما بدك تمحيها بالبانكربسي والديون اللي أنت بتريد تمحيها بالبانكربسي. بعطي مثل، يمكن أنت عم تدفع المورجج تبع بيتك بس هيدا دين you have to list it، وأنت بعدك عم تدفع، بس أنت عندك $60,000 كريدت كارد ما بقى عم تدفعها وبدك تتخلص منها، كمان بتسكرها. يعني الدين اللي أنت on time والدين اللي أنت مش on time بدهم ينذكروا. وقت اللي بتوصل البيتيشن للمحكمة، المحكمة بتبعت رسائل لكل صاحب دين. كمان مرة الأكسس اللي بينتظروا كل شهر child support alimony أو spousal support، هيدول أصحاب ديون. حتى لو اللي بده يقدم البانكربسي البيتيشنر عم يدفع on time لازم يكونوا مذكورين. وإذا انذكروا وقت بتجي البيتيشن لعند المحكمة، المحكمة بتبعت رسائل لكل إنسان ولكل شركة مذكورة بالديون اللي عم يندفعوا on time واللي ما عم يدفعوا on time. So وقت اللي هذا الشخص مثلا الأستاذ خالد قدم bankruptcy، شركة من الشركات المذكورة بالسكادجول هي اللندر وصلت له نورس. هذا اللندر مفروض يعرف إنه ما بقى يقدر لا يتصل فيه ولا يروح لعنده بالليل وياخذ له السيارة. هلأ اللي بيصير أوقات رامي إنه الإنسان بيكون ما عم يدفع السيارة، قدم بانكربسي ليحصل على الحصانة، بس بعده بده يسوق السيارة، يعني ما بده يدفع، بده يسوق ببلاش. That does not work. So اللي بيصير أوقات إنه اللي مأخرين بدفع السيارة وقدموا الإفلاس صحيح إنه القانون بيقول إنه ما بقى فيك تطالن، ما بقى فيك توصلهم لأنه عندهم حصانة. هون صاحب اللندر بيقدم طلب للبانكربسي كورت وبيقول لهم إنه غير إنصاف إنه هذا الشخص من جهة ما عم يدفع ومن جهة تانية عم بيسوق. فبنطلب من المحكمة ترفع الحصانة بس لنرد السيارة. الدين بينمحى، لنقول الإنسان مأخر 4 أشهر بس عم يستعمل السيارة، الدين رح ينمحى بالبانكربسي، بس ما بيحق له يضل يسوق السيارة كمان مرة. ما رح يوعى هذا الشخص اللي مقدم بانكربسي ويكتشف إنه السيارة تبعه اتخذت من قدام بيته، لأنه بدهم يعملوا إجراءات، يروحوا على المحكمة ورح يكون عنده علم، لأنه المحكمة رح تبلغه لصاحب الشأن. بالنسبة لتاني سؤال الأستاذ أحمد، هل فيني أقدم بانكربسي وأنا ما عم بشتغل؟ تقديم البانكربسي ما خصه بالشغل ولا مش بالشغل. تقديم البانكربسي بفتكر بيساعد الإنسان اللي ما عم يشتغل، لأنه بالنهاية للمحكمة تحدد إذا الإنسان مؤهل يقدم بانكربسي واي نوع من البانكربسي. تشابتر 7 اللي هي بتنظف كل شيء وببلش الانسان على بياض، ولا تشابتر 13 اللي هي بتنظف جزء كبير من الديون وما تبقى بيتقسط على 3 ل 5 سنوات لقدام. تتقرر المحكمة بدها تطلع على مدخول الإنسان أو أصلاً وشو عنده. يعني في 4 عوامل هون بيطلع عليهم مثلا مايكل ليشوف إذا هيدا الإنسان مؤهل لتشابتر 7. وحدة منهم من بعد ما يدفع تكاليفه المهمة، مش عم نحكي going out to a restaurant، بس عم نحكي يدفع DTE bill، يدفع المينيموم رنت إلى آخره، الأشياء الضرورية. إذا بقي له كتير قليل يمكن مؤهل لتشابتر 7. إذا عنده بيت وفي كتير اكويتي يمكن مش مؤهل لتشابتر 7. خلاصة الأمر لنرجع لموضوع employed أو unemployed، وقت اللي بيطلع المحامي على قديه مدخول هيدا الإنسان، إذا كان جاي من الانemployment agency وقديه مصروف هيدا الإنسان للأشياء المينيموم البدائية، هون بيقدر المحامي يحدد إذا هيدا الإنسان مؤهل يقدم تشابتر 7 أو مؤهل يقدم تشابتر 13 ولا منه مؤهل يقدم anything at all. يعني the analysis is the same، بس إجمالا الإنسان الانemployed ما عم بيطلع أو عم بيطلع شيء كتير قليل، وبفتكر هيدا الشيء بالعموم strengthens their case إنه يقدموا bankruptcy. So مش كافي نقول employed أو unemployed لنقرر إذا هيدا الإنسان مؤهل يقدم إفلاسه. ثالث سؤال، هل بنقدر نحصل على مورجج من بعد البانكربسي؟ البانكربسي السبب من الأسباب يعني إنه العالم ما بتحب تقدمها لأنه بتخرب الكريدت سكور وبتاخد وقت لحتى يرجع الإنسان يبني الكريدت سكور. بتاخد أقل وقت مما الواحد بيفكر، بس بتاخد وقت بالأقل أقلا بالبداية. المحامي مايكل بانكستين بيقول إجمالا للإنسان يحصل على مورجج، إجمالا كقاعدة عامة بده solid 3 سنوات وسلوك جيد، of course سلوك جيد، payment on time everything، وما يكون في كتير debit to credit ratio على الكريدت كاردز تبع الإنسان. هيدي شغلة ما بنحكي كتير عنها على فكرة. إذا إنسان عنده مثلا بالانس، إذا عنده كريدت كارد بحق له يصرف عليها 10,000، إذا ما عم يدفعها in full وقت اللي هي مدفوعة، إذا بيقدر يدفعها in full that's the best way to spend money using other people's money. but إذا ما بيقدر ما لازم يكون عنده أكتر من 40% عليها. يعني اللي عنده 10,000 ماكسيموم ما لازم يحط أكتر من 4,000 5,000. but كل ما بنوطي الدين على اللي ماكسيموم allowed كل ما هيدي أحسن، لأن هيدي من العوامل اللي بتحدد الكريدت سكور تبع الإنسان. debit to credit ratio، debit هو مثلا عم يصرف صارف 4,000، الكريدت هي عليها 10,000. إذا بيكون الديبت تو كريدت ريشيو لا أكثر من 40-50% بيكون كتير منيح، هيدا بيساعد الكريدت سكور. بدنا نرجع للسؤال، بيقول المحامي مايكل بانكستين بالمعدل 3 سنوات، وأوقات وحسب المورجج كومبانيز، في منهم سهلين أكثر، في منهم قاسيين أكثر، في منهم يمكن يعطيك مورجج بس يكون كتير الانترست ريت عالي إلى آخره إلى آخره. انتقالا الأشخاص اللي بيجوا لعنا، أوقات بيجي طرف من الطرفين المتزوجين بده يقدم بانكربسي. هل دو وي فايل؟ هل هي فكرة منيحة إنه الشخص بس يقدم؟ هل لازم الاثنين يقدموا؟ وأيمت؟ أول شيء خلينا نحدد المتزوجين قانونياً. على الأقل بولاية ميشيغان القانون بيقول لتكون معترف فيك إنه أنت متزوج قانونياً، ما بيهم متجوز بالكنيسة أو عند الشيخ، المهم هل أخذت إجراء إضافي اللي هو نزلت على سيتي هول وطلبت مارج لايسنس وعبيتها وسلمتها، هون بينتقل زواجك ويعترف فيه انه هو زواج شرعي. للاشخاص السيفلي مارد، للاشخاص اللي مضجوا المارج سيرتيفيكت وصاروا معترف فيهم انه هن متزوجين، وقت اللي بيجي طرف من الطرفين بدنا نستعلم عن ديون هيدا الشخص. إذا ديون اللي إجا لعنا، لنقول الزوجة على سبيل المثال، إذا ديونها متشاركة مع زوجها، إذا قدمت هي إفلاس رامي، المسؤولية بعدها من 100 على جوزها. إذا عندها كريدت كارد معه ومع جوزها، أوكي، المسؤولية راحت عنا إذا قدمنا لها كريدت كارد، بس إذا قدمنا لها بانكربسي بس المسؤولية ما راحت عن زوجها. إذا مفترقين عن بعضهم وما بيهمها شيء، بس إذا هن متزوجين، الغاية اللي هي جاية فيها ما رح تقدر توصل لها، لأنه النتيجة رح تكون هي ذاتها، شيلتها عن ظهرها بس حطتها 100% على ظهر زوجها. هن بزواج حقيقي بيحبوا بعضهم، it's useless. أول شغلة نطلع عليها إذا الديون مشتركة. هلا ما عم نحكي ديون صغيرة كمان. دايما البانكربسي هي لاكبر نهار اسود، مش لاول نهار اسود. في اوقات في غير طرق، في غير حلول. اذا الديون مشتركه، اذا هي قدمت، هي ما بقى عليها مسؤوليه، بس المسؤوليه ما زالت 100% على the non-filing spouse، الزوج او الزوجه اللي did not file. شغله ثانيه، اذا النون-filing spouse كمان عنده كتير ديون، وكمان هو يمكن بحاجه لبانكربسي، ساعتها حتى لو ديونه مختلفة عن ديوننا، بنقدر نقدم لهم مع بعضهم جوينتلي، يعني بنقدم طلب واحد، بندفع مرة واحدة وبنقدم لاثنين. في كمان في ظروف معينة بتمنع الزوج أو الزوجة يقدموا إذا كان النون فايلينج سباوس مدخوله جيد جدا. عطينا على سبيل المثال موكلة إجت لعنا من تقريبا 2 بدها تتزوج رجال كان كتير الله منعم عليه أو غني whatever you wanna call it. إذا تزوجته وهي عندها ديونة، إذا قدمت على بانكربسي من بعدها ما رح تسمح لها المحكمة تقدم، لأنه المحكمة وقت الإنسان متزوج قانونياً بتطلع على المدخول اللي بيفوت بقلب العائلة، ما بتطلع فقط على نص العائلة، نص الكابل. حتى لو هي عندها ديون، إذا كانت تزوجته وهو مدخوله جيد وجيد جدا، المحكمة حتى لو قدمت طلب رح ترفض لها الطلب، لأنه في مدخول حرزان عم يجي على البيت. الحل إلها كان إنه تقدم بانكربسي وتطلع من البانكربسي قبل ما تتزوج، وهيك عملنا لها. She filed for bankruptcy and she was discharged from Chapter 7 before she married her husband. أوقات المدخول تبع الطرف الآخر اللي ما بده يقدم رح يمنع الطرف الأول، رح يحرمه من قدرته إنه يقدم بانكربسي، لأنه المدخول بالبيت كتير. مثل ما قلنا رامي، هيدا عامل كمان بنشوفه in other areas. مثلا الإنسان اللي بيقدم على SSI بياخدوا بعين الاعتبار المدخول كله بالبيت، صح؟ تتذكر من الاشياء اللي بنقولها انه اللي بياخد SSI وحدا من العائله بيحصل على مصاري اكثر، لازم تبلغ السوشيال سيكيورتي ادمنستريشن باي ذا 6 of the following month. ليه؟ لانه يمكن الSSI إلك انت ينزل مع انه ابنك هو اللي عم بيطلع، بس اذا عايش معك بالبيت بياخدوا بعين الاعتبار مدخوله. هيدي this legal notion انه ناخذ بعين الاعتبار المدخول الكامل بالبيت، هيدي شايفينها نحن من قبل، شايفينها مثلا with SSI. لهذا السبب اوقات مدخول الطرف الاخر بيحرم الطرف الاول منه يقدم bankruptcy. To file jointly or separately is it's a very detailed discussion that has to do with everybody. One, you have to be civilly married. Number 2, we have to look at the income of your non-filing spouse. We have to look at the kind of debt. If it isn't common, it's pointless to file on your own. And if your spouse, non-filing spouse, also has a lot of debt, your non-filing spouse should join you in the bankruptcy and file. إذا حدا بيحب يبعت أسئلة this is a good time قبل ما نبلش بموضوع تاني اللي هو عن الأشخاص اللي حاسين حدا رح يقيم دعوة ضدهم إن كان كريدت كارد إلى آخره. you have to be a step ahead of it، لأنه أول ما يطلع أمر money judgment بأقل من 30 نهار ممكن يكونوا راحوا على السكرتاري أوف ستيت يشلحوك الدرايفرز لايسنس تبعك، حريتك إلى آخره. So أي شخص بحب يبعت أسئلة 313 327 7074 313 327 7074. إذا بناخد بس وقفة 30 ثانية وبنرجع.
يقول بعض المصابين في حوادث السيارات إدارة قضاياهم توفيرا لأتعاب المحامين. والآن مكتب المحامية جومانا كيروز بإمكانه المساعدة من خلال إشرافه على سير القضية في جزئها الأول المتعلق بتعويضات الراتب والخدمات المنزلية، وتقوم بإرشادك في كيفية إدارة ملفك مجانا، بينما سيتولى المكتب مهمة الدفاع عن قضيتك في جزئها الثاني المتعلق برفع دعوى عن عطل وضرر. للمزيد من المعلومات اتصلوا بمكتب المحامية جومانا كيروز والاستشارات مجانية 248-557-3645. هل أنت مضطر إلى إشهار إفلاسك؟ لا تأخذ هذه التجربة لوحدك، بل استشر أولا ومجانا مكاتب المحامية جومانا كيروز، وتكلم مع المحامي المختص بقضايا الإفلاس مايكل بنكستين، الذي سيساعدك على التخلص من ديونك وفقا للبند السابع لقانون الإفلاس بسعر $575 فقط. ومن الممكن أيضا أن تحصل على إعفاء من أتعاب المحكمة اعتمادا على عدد أفراد الأسرة ومدخولك الشهري. اتصل الآن بمكاتب المحامية جومانا كيروز 248-557-3645 والاستشارة مجانية. Your Rights مع المحامية جومانا كيروز. عودة إلى برنامج Your Rights مع المحامية جومانا كيروز. موضوع الحلقة اليوم عن الإفلاس مع المحامي مايكل بنكستين. أرقام الهواتف في الاستوديو 313-769-6666 519-256-1023 وعلى الواتساب 313-327-7074. جمانة، قبل ما تكملون الموضوع أكثر وبتفاصيل أكثر عن الإفلاس، في موضوع العقود، يعني مثلا شخص، السؤال اللي وصلنا من المستمع على الواتساب إنه هل لما يقدم على الإفلاس راح يأخذون السيارة الخاصة به المتعلق، يعني هي سيارة إيجار أو ليس؟ العقد هذا يعني عقد الإيجار أو ربما المورجج، هل يلغى أيضا جمانة؟
عم تحكي عن سيارة يعني مش مورجج، يعني ليس قصدك؟
نعم، مثلا الليس الأجريمنت اللي وقعها وبعدين قدم على البانكربسي وأخذوا السيارة، هل يعتبر العقد لاغي بهذه الحالة أم أنه احتمال يطالبوه بشروط جزائية مثلا بعد ما تتعدل الأوضاع لهذا الشخص؟
أنا أكيد تقريبا 100% من الجواب اللي هو يس. غايب لنقول مثلا أنت أخذ سيارة وعم بتقسطها وبعد عندك على العقد سنة ونص وقدمت البانكربسي تبعك، إذا مؤهل أنت للبانكربسي ما تبقى من العقد يلغى absolutely. بس السيارة مثل ما قلنا بدها ترجع، ما فيك تلغي العقد وتحافظ على السيارة. It's going to be one or the other. بدي أتأكد وأسأل مايكل، بس أنا أكيد تقريبا 100%. Attorney Michael Benkstein, going back to the هيدي غاية البانكربسي رامي، إنه تتخلص من ما تبقى من عقودك. Attorney Michael Benkstein, going back to the question about repossessing the car. Let's say that gentleman had a financing agreement regarding a car, and he had a year and a half remaining on that financing agreement, and he files for bankruptcy. Is the remainder of that financing agreement wiped out in bankruptcy?
Here's how it's treated in bankruptcy. If it's a Chapter 7, it's kind of a swinging gate. You either keep the vehicle and continue to make the payments under the existing contract terms, or you could surrender the vehicle and give it back and not have to make the payments anymore. In a Chapter 7, it's really kind of you keep it and continue to make the payments, or you give it back and you don't have to make the payments. In a Chapter 13...
But to be very specific, let's stick to Chapter 7 for 1 minute. But to be very specific, if he surrenders the car and he has a year and a half remaining on his contract with the financing company, his liability is off. His responsibility is gone as to the remaining payment under the contract if he files and gets discharged in bankruptcy, correct?
Correct, if he surrenders. I just wanted to clarify that you don't magically keep the car and dump the debt. Yes.
No, you cannot. Okay, what about Chapter 13?
In a Chapter 13, they have this interesting rule that only applies to Chapter 13s in our district. If you've owned the vehicle for at least 910 days prior to the filing of the bankruptcy, you can, when you're paying it inside the Chapter 13 plan, you can cram the secured claim, what you owe on the car, down to its present market value. But that's only if you've owned the car and the debt on the car is at least 910 days old prior to the filing of the bankruptcy, and you're paying the vehicle inside the plan.
Okay, we will talk about that next time because I don't know that I fully understood it. I'm going to make a note, and God willing, next Friday or at a future time, we'll talk about this. Right now, to answer your question, Rami, he either pays and keeps the car, although he's filing bankruptcy on something else, or he gets released from that remaining obligation on the contract, but gives up the car. You can't have it both. You cannot wipe out your obligation under the contract and get to keep the car. It's either one or the other. لأرجع جاوبك رامي على سؤالك، الإنسان اللي بعد عنده payment إن كان ليس أو إن كان عم بيقسط سيارة شارية وقدم bankruptcy بده يرد السيارة، بس بالمقابل إلها العقد اللي هو بعد مجبور عليه، لنقول كان عنده سنة ونص لحد اليوم واليوم قدم bankruptcy، شو بصير بالواجبات على السنة ونص؟ رح تنمحى. It's going to be wiped out in bankruptcy. It's going to be discharged in bankruptcy. بس مش رح تنمحى ويترك السيارة، تنمحى ورح يرد السيارة. So هيدي من غايات ال filing of bankruptcy، إنه واجبات الإنسان حسب شو هي الواجبات وكيف whatever, it will be wiped out. So his contract obligations will be wiped out, will be discharged in bankruptcy. It will be treated like credit card debt. It will be treated as anything else that gets wiped out in bankruptcy. But he cannot have the cake and eat it too. Anything else you want to add on this, Michael?
No, thank you. That's a great summary.
Right, and let's limit this to Chapter 7. Chapter 13, there appears to be another rule that has to do with if you have owned the car for more than 900 days, which is like 3 years and all of that. I made a note, and we will talk about it next time. With the 10 minutes remaining, 9 minutes remaining, tell us, Michael, why, if you fear that you are going to be sued for a money judgment, and most suits are for money judgment, by the way. There are very few lawsuits for injunctive relief, where you're asking the court to order the other person to do this or not do that. I'll give an example. If you're suing somebody for real estate property, the law says real estate property is very, very unique. So you may be able to get the court to order the person you're suing not to sell the building or not to sell the house. That's called injunctive relief, meaning you're asking the court not to pay you money, but to order the other person you're suing to do something or not to do something. But the greatest majority of lawsuits are for money damages, meaning you are suing somebody and you're requesting money. If, God forbid, you fear or you just got sued for money damages, a good example, a classic example, you owe money for a credit card company. If you stop paying it, sooner or later, they're going to sue you. An unpaid medical bill, sooner or later, they're going to sue you. If you know you're going to be sued, if you feel it's coming, or you just got sued, act very quickly. Michael, tell us why.
You want to act very quickly because if you're sued, you only have a certain amount of time to respond to the lawsuit. If you're served in person with a lawsuit in Michigan, you've got 21 days to respond. If it was served to you by mail, you've got 28 days. But once that notice period comes and goes, they can go to the court if you haven't filed a response, and they can say, hey, court, on such and such a day we filed the case, and on such and such a day we can prove it. We got the affidavit of the process server that we served it. Well, 21 days came and went. We haven't received a response. Court, have you received a response? Nope. Default judgment. They could be as wrong can be, and you can be as right can be. But if you had a chance to do that and you didn't do it, the court's going to say, well, you must agree, and they're going to enter a default judgment. Prior to the default judgment, if you owe people money, they can call you and they can write you and they can be a real pest, but they can't do anything to you until they get a judgment. As soon as they get a judgment, it's off to the races, as they say. As soon as they get that judgment, they can collect on a judgment. Now they can hit your bank account. They can garnish your wages. They can intercept your tax refunds. So you want to operate from a position where, you can kind of kind of guided into a soft landing into a bankruptcy instead of, be trying to do a bankruptcy and put that together in the midst of you don't have any money in your bank account. People are trying to do things. Yeah. So try to put the timing under the best circumstances for you is kind of what I recommend.
Yes. And in addition to, they can garnish your wages, they can garnish your bank account, they can garnish any paychecks you get, they can garnish any rent payments you get, they can garnish any land contracts you have, they can garnish any contract payments you receive from anybody, and they can go to the Secretary of State and suspend your driver's license, which is a very, very big deal. So you want to be ahead of it. I'm looking at those forms that we talked about back in February. These forms that if somebody has a judgment against you, whether it's a credit card or whether it's somebody else for money, these are forms that are relatively very easy and they're so detailed, available online. They are approved by the court. One of them, you fill it out if somebody owes you money, and it is called garnishee disclosure. And the instructions on the following page, I mean, anybody can do it because they are so detailed how to fill out the disclosure form so that you can garnish somebody's paycheck, so that you can garnish somebody's bank account, so that you can garnish somebody who you know to be a landlord and they get rent payments and whatever it is. And you can garnish also, I'm looking at the other form that we did talk about also on February 19 and February 26, how to garnish somebody's income tax refund. So once you have a judgment against somebody, all you have to do is fill out those forms and they will garnish the IRS, the state of Michigan. No, let me take that back. The garnishment for tax refund is only state of Michigan, not IRS. Do you remember that, Michael?
State. Well, yes.
State.
Sorry.
Yes, it is only the state. You can only garnish somebody's Michigan state taxes, not federal.
That's correct. So your garden variety creditor, credit cards, medical bills, that kind of stuff, they can only garnish the state tax refund. They cannot garnish the federal income tax refund. Although if you owe something like child support or various other kind of debts like that, then they could potentially take it. But credit cards, medical bills, all the kind of usual creditors, they can't touch your federal income tax refund. That's correct.
Right. So that you are not in that position where things are getting garnished and driver's license are getting taken away from you. If you think you're going to be sued or if you got sued, this is the time to act. And what do we mean by act? This is the time to consult with a bankruptcy attorney and see if the option is to file bankruptcy. Why? Because once you file bankruptcy, they can no longer garnish your wages. They can no longer garnish your payments. They can no longer garnish your paychecks. They can no longer garnish your rent payments. They can no longer garnish your bank accounts. They can no longer garnish your income tax returns from the state. All of that does stop if and when you file for bankruptcy. So that is why you don't want to wait until there is a judgment against you, or you don't want to wait until you don't answer the lawsuit and they enter a default judgment. We call it in Arabic حكم غيابي, لأنه الحكم الغيابي is just as good as any judgment and they can act on it. Attorney Michael Benkstein, fabulous show. Thank you so much for the wonderful information. Rami will be downloading this show on our YouTube channel, the Joumana Kayrouz YouTube channel, and people can listen to it again. Rami, thank you so much. Happy weekend, safe weekend to everybody. And God protect everybody from floods today.
Thank you جمانة، شكرا جزيلا، وأكيد لكل مستمعينا على حسن المتابعة. دمتم في رعاية الله وحفظه، إلى اللقاء. حاول بعض المصابين في حوادث السيارات إدارة قضاياهم توفيرا لأتعاب المحامين، والآن مكتب المحامية جومانا كيروز بإمكانه المساعدة من خلال إشرافه على سير القضية في جزئها الأول المتعلق بتعويضات الراتب والخدمات المنزلية، وتقوم بإرشادك في كيفية إدارة ملفك مجانا، بينما سيتولى المكتب مهمة الدفاع عن قضيتك في جزئها الثاني المتعلق برفع دعوى عن عطل وضرر. للمزيد من المعلومات اتصلوا بمكتب المحامية جومانا كيروز، والاستشارات مجانية. 248-557-3645.